Roy is recognized for 5 minutes.
I thank the gentlelady. Mrs. Reardon, when the United States Supreme Court struck down Section 5, they did so, best of my understanding and recollection, in significant part because it was based on, at that time, 40-year-old data, and that it was based on information from 1968, 1972, and it was particularly dated. And in particular, that the record that was put into the record in 2006 when VRA was reauthorized at the time was replete with examples where there were covered jurisdictions that had certain issues that were being raised, and then non-covered jurisdictions, but there was no real correlation, and that was part of the problem. Is that roughly correct from your recollection of the case?
Yes, it's definitely that there seemed to be no legitimate basis to have certain states covered at that particular time. And I think also the Supreme Court was very clear in what they said was it was always supposed to be a temporary provision because they understood in the 1960s that there was, it was necessary to have Section 5, but that in the 2000s, it's no longer necessary.
Ms. Reardon, do you think the Department of Justice is particularly objective in the way that it would carry out preclearance? And just a simple answer on that one, and then I have to follow up.
I do not.
Are you familiar with the Department of Justice Inspector General report from 2013?
I am.
Are you aware that Chapter 4, Part 3 of the report, page 135, highlights that disclosures and other confidential information was leaked to reporters, likely by voting section employees?
Yes, that would happen on a regular basis.
And what kind of information was leaked? Can you provide examples, keeping in mind we're on the clock, but a few examples for the committee?
I think during the I want to say the Georgia voting ID case, there were individuals who leaked information from the inner workings of the group that was responsible for reviewing that particular submission. I can think of that. I know that there were a couple of, actually one particular attorney that claimed that she was the basis for one of the books that was written about the DOJ. Those are just two examples.
Are you aware of the report highlighting that analysts lied under oath?
I am.
And do you have any background or examples of that?
I know that during the Inspector General report that there was a civil rights analyst that was specifically asked a question by the attorneys that were doing the investigation, and that she lied under oath.
The report provides examples of non-attorney voting section employees, posting comments to websites concerning voting section personnel or matters. One example describes an employee who started a, quote, cyber gang, unquote, that was engaged in, quote, cyberbullying, end quote. According to the report, he told the OIG that for his internet postings, he selected as his alias the name of the protagonist of a well-known novel because he represented the archetype angry black guy, end quote, page 129 of the report. Are these the same people that would be doing pre-clearances of election law changes under H.R. 4?
Yeah, there are some of those same people there.
Is that troubling to you?
Yes. I mean, one of the things that I found to be so shocking while working in the voting section was the fact that it was so political. I just think that a section that is termed voting, that is supposed to review voting changes in the Civil Rights Division, should be nonpartisan. It is the furthest thing from nonpartisan.
I apologize for being a little bit late. I had a conflict, but I suppose there's been some conversations here about H.R. 1 and S1 and about some of the issues involved with those pieces of legislation. Obviously, right now, having hit a wall in the Senate, do you believe that H.R. 4 is trying to be used as a backdoor to try to get the federal takeover of elections carried out in the absence of being able to currently get that executed on the Democratic side of the aisle?
I do. I think that this particular bill is looking to reauthorize a provision of the Voting Rights Act that is no longer necessary because there is no rampant discrimination in voting. One of the things that I said earlier was the fact that during the time period that I was there from 2000 until 2013, there were 222,000 submissions that were submitted by local jurisdictions. I would say that 98% of those submissions really concern moving a polling place within the same building. There is just not rampant voting discrimination between 2000 and 2013. There certainly isn't today.
When my colleagues on the other side of the aisle say that, quote, the Voting Rights Act has basically been, turned over or overturned by the court, that's not true, is it, right? We're talking about Section 5. Voting Rights Act remains firmly in place, protects the rights of American people to vote. but rather what we're doing is allowing states to continue to be able to figure out the laws and place voting booths where they need to be and so forth. Would you agree with that?
I would.
Thank you, ma'am. Yield back.
Thank you, Ms. Ross, for taking the chair. Take the chair and recognize you for your 5 minutes of questioning.